media, calling them liars, calling them corrupt, saying that one would be jailed and that one was a racist. He then, 3 days before a scheduled deposition, posted on Instagram that after this upcoming round of depots, he, quote, would love to start a shooting campaign. Mr. Lee's misconduct not only led to that protective order, which required depositions to be held in a secured location with armed officers present, it also resulted in a 2-year suspension order in federal court. Also regarding his recalcitrance in refusing to own up to the objectively threatening content of his post. His conduct also resulted in 4 sanction orders imposing monetary sanctions, which he hadn't paid at the time of the trial and the disciplinary proceeding. It resulted in a gag order, 3 contempt orders, not only for his repeated violations.
On April 10th, 2023, the Florida Bar filed a 6-count complaint charging Respondent Malik Lee with 24 violations of the rules regulating the Florida Bar. The allegations arose from 2 sets of cases: litigation Mr. Lee brought against his former employer, the Palm Beach County School District, and a class action he pursued on behalf of the residents of the Stony Brook Apartments in Riviera Beach. Following a 6-day hearing, the assigned referee filed a report on October 11th, 2023, finding Mr. Lee guilty of several of the charged violations and recommending a 91-day suspension followed by 2 years of probation. On December 11th, 2023, the bar filed a notice of intent to seek review of the referee's report, contending that the referee's findings were deficient and that the full scope of Mr. Lee's misconduct warranted disbarment rather than a suspension. On September 10th, 2024, the matter came before the Supreme Court of Florida for oral argument, with the Florida Bar being represented by counsel Mark Mason and Mr. Lee being represented by attorney Juan Carlos Arias.
Welcome to the Florida Supreme Court. Our first case today is Florida Bar versus Malik Lee, case number 2023-0518.
May it please the court. My name is Mark Mason, and I represent the Florida Bar in this disciplinary proceeding against the respondent Malik Lee. The bar filed a 6-count complaint regarding 24 rule violations involving a 3-year pattern of ongoing misconduct. This occurred in employment discrimination cases filed in federal court in the Southern District, and also occurred in circuit court litigation involving the living conditions of an apartment complex and an attempted class action. Before this disciplinary proceeding, Mr. Lee's misconduct had already been the subject of a protective order, not merely because he disparaged defendants, school officials on social media, calling them liars, calling them corrupt, saying that one would be jailed and that one was a racist. He then, 3 days before a scheduled deposition, posted on Instagram that after this upcoming round of depots, he, quote, would love to start a shooting campaign. Mr. Lee's misconduct not only led to that protective order, which required depositions to be held in a secured location with armed officers present, it also resulted in a 2-year suspension order in federal court. Also regarding his recalcitrance in refusing to own up to the objectively threatening content of his post. His conduct also resulted in 4 sanction orders imposing monetary sanctions, which he hadn't paid at the time of the trial and the disciplinary proceeding. It resulted in a gag order, 3 contempt orders, not only for his repeated violations of that gag order, but also for failing to take CLEs to address the ongoing civility and professionalism problems he was exhibiting. And then there was also, yes.
Let me ask you a quick question. It seems like the actions that occurred in one instance, in the civil case, they happened in September 2016, 2017. And then the second case, they had that happen between 2018 and 2020. We're in 2024. Why did it take this long to reach the Supreme Court or any place else?
Part of it was the scope of the misconduct. Certainly, as he committed more and more violations, it added to the investigation and the time it took to complete that. What added on to that further was that his co-counsel was his law partner was actually co-counsel on all these cases, since the bar was also investigating her regarding her role, if any, in the misconduct at issue.
I'm sorry to cut you off. So the first referral to the Florida Bar occurred in 2017, right, by the federal court. And you're telling me from 2017 till 2023, it took that long for the Florida Bar to get through at least the initial conduct that generated the referral. Why did it take so long? I'm struggling to figure that out.
Yes, Your Honor, and I understand that this case could have been handled more promptly. And I certainly understand that from the reporter referee as well. What happened is that the bar started investigating these things and decided to file one formal complaint. In retrospect, with how long it took, should the bar have prosecuted on the earlier cases? Probably, yes. But we ended up doing a comprehensive 6-count complaint in 2023 for conduct that spanned from 2017 to 2020. So I understand if you take the earlier misconduct, you have 6 years between that and the bar's complaint. But this was ongoing for 3 years, and it did involve an extensive investigation, a 60-plus page formal complaint, and 1,600 pages of appendix that was just attached to the formal complaint alone. I'm not even talking about the trial exhibits yet.
But
So-
once the bar, filed the complaint, the process took, what, approximately 7 months?
6 to 7 months it took from the formal complaint until the conclusion of the 6-day trial.
Okay.
He had been a lawyer, member of the bar, beginning with the first case, the 2016, 2017 case, for only 5 years, correct?
Correct, 2011.
And
he became
then
lawyer.
when the second case occurred in 2018, he had been a member of the bar for 7 years at that time. So all this behavior, all these issues that were raised in this case happened during his early years. Because I think he's like 49 years old.
Correct.
He's
At the-
admitted in 2011.
Yeah, at the time of trial, the reporter referee says he was 49 years old. As far as the inexperience goes, even if you would consider that a mitigating factor, that's all it is. It doesn't excuse the misconduct. And the nature of the violations we're talking about here were intentional violations of court orders. It was not.
But the inexperience might relate to making missteps, going down the wrong path. But when you're told you're going down the wrong path and you keep going and keep going and keep going, that's not just inexperience. That is incorrigible conduct. Am I wrong about that? I mean, that's basically the bar's position, isn't it?
That's exactly the bar's position, yes, Your Honor. Really, we sought review for 3 reasons. Obviously, the sanction is the primary one. But within that, there's 2 issues. The referee's findings of not guilty on count 2, which had to do with the pretrial stipulation filed by opposing counsel. She input an electronic signature on it. There was some confusion as to which version was the correct one, but rather than call her up about it, he does a public filing that accuses her of criminal forgery. And then he follows it up by contacting law enforcement agencies to seek criminal charges against her. The referee found her, Mr. Lay, not guilty on the 2 rule violations at issue in count 2, saying that it was an isolated instance of misconduct. The bar is asserting
Are you?
that. Yes.
Yeah, and so that's the way you read the report. I mean, because the report is kind of incoherent on that. I mean, it says that at the top part, but then when it's going through the sanctions, it talks about having found violations on all the charges. So what are we to make of that?
Your Honor, I agree that the largest issue with the report or referee is that it glosses over the underlying misconduct. You could read the report or referee's counts 1 and counts 3 through 6, and you would have almost no idea what the misconduct involved. Count 2 contains the most amount of facts, and it still just talks about the different versions of a pretrial stipulation going back and forth, but it doesn't even mention the fact that he was contacting law enforcement agencies.
So are we supposed to be the ones making the findings then? Because it's hard to read that report as really having made findings. Are we supposed to be doing that now, or what?
Yes,
What's the
Your Honor.
posture?
I wouldn't argue for remand in this case because we submitted the court orders that firmly established the misconduct. I mean, all of the conduct that I described in my brief, I know just the statement of facts in my brief alone was 48 pages, but it's all derived from court orders that are final, that either weren't appealed or they were appealed unsuccessfully. All of the findings that are pertinent to determining the appropriate sanction are within those orders that I referenced in my opening. So with regard to count 2, it certainly wasn't an isolated instance of unprofessionalism. This wasn't just a single nasty email with what he did. This was a campaign to try and get her arrested, to try to paint her as some criminal. And, that violated the 2 rules at issue, which was 4-8.4A and D, having to do with conduct prejudicial to the administration of justice. And it was humiliating and disparaging for the other attorney.
Mr. Mason explains that the bar sought review of the referee's report because it disagreed with the recommended sanction, and it disputed the referee's finding that Mr. Lee was not guilty of the violations charged in count 2 of the complaint. When the bar files a formal complaint, an appointed judge serves as the so-called referee, a role comparable to that of a trial judge in a non-jury proceeding. Under Rule 3-7.6 of the rules regulating the Florida bar, the referee conducts an evidentiary hearing, makes findings of fact, determines whether the charge rules were violated, and then recommends a sanction. However, according to Rule 3-7.7, the resulting report is subject to review by the Supreme Court of Florida. And as the court explained in the 2005 case of Florida Bar v. Barrett, it is ultimately the court's responsibility to order the appropriate sanction. Now, in Mr. Lee's case, the 6-count complaint alleged misconduct including publishing threatening and disparaging social media posts about opposing parties, filing scandalous and legally deficient pleadings, disobeying court orders, pursuing a frivolous claim, using a court reporter to question a represented party outside the presence of her counsel, and accusing the presiding judge of racial bias without a factual basis. Additionally, count 2 of the complaint, which charged violations of Rules 4-8.4a and 4-8.4d, alleged that Mr. Lee falsely accused opposing counsel of forgery and contacted law enforcement agencies to seek criminal charges against her. These rules are part of the rules of professional conduct set out in Chapter 4 of the rules regulating the Florida bar. Rule 4-8.4a prohibits a lawyer from violating or attempting to violate the rules of professional conduct, and Rule 4-8.4d prohibits conduct connected to the practice of law that is prejudicial to the administration of justice, including the knowing or callously indifferent disparagement or humiliation of other lawyers. The bar's position was that this conduct violated both rules, and that the referee erred in treating it as an isolated lapse rather than a sanctionable violation.
And with regards to count 3 through 6, which was mostly focused on the circuit court litigation, the attempted class action, there's almost no findings whatsoever in the report of referee. It just references what the bar's formal complaint charged. And on that issue, what the referee did is she attempted to recommend diversion on those counts. But the problem with that is the rule governing diversions after the submission of evidence says you can only do that when there's minor misconduct. This misconduct was not minor. I mean, even the referee, for all the omissions that may be within that report or referee, she's recommending a rehabilitative suspension. She recognized this conduct is not minor at all. Diversion is not appropriate, and you can't just separate the counts and isolate your review to say, well, this misconduct was minor even if this other misconduct wasn't.
What is the bar's recommendation? What are you asking us to do?
The bar is seeking disbarment for Mr. Lay in this case. This is his first disciplinary proceeding, and I know generally speaking it's unusual to go straight from no discipline whatsoever to straight disbarment. But the reason the bar is asking for that is because of the 3-year pattern of intentionally violating court orders, especially in the class action litigation.
Can you address Standard 6.2 in the context of this case? Disbarment when there's an intent to benefit, and then harm and serious harm. Is that not kind of an assumption in this case? Why is that so clear from the record?
The Standard 6.2 deals with serious interference with the legal proceeding and knowing violations of court orders. And those were findings by the presiding judges and magistrates repeatedly in the court orders in which they sanctioned Mr. Lay. They said that he offers these excuses and he attempts to confuse matters and just to rely on his ability to talk his way out of things, but he's not taking responsibility. I mean, we're talking 2023 complaint versus 2017 misconduct. I understand the delay issue, but at the same time, he's had all that time to complete CLEs, to even enter into payment plans to pay these sanction fees, and he didn't do it until the referee exhoriated him at trial and said, you better do something. And then he comes back to the stand the next day and says, well, I just emailed opposing counsel and I inquired about getting on a payment plan. These were all steps that could have been taken earlier.
And I guess the distinction between suspension and the disbarment, I think, would be harm, right, to the client. Right. Potential harm. And so why, I guess the argument is that the clients ended up getting a benefit from the proceeding. It took a while and it was despite this, but can you address the harm aspect specifically in terms of disbarment versus suspension?
In count 4, one of the sanction orders imposing monetary fees that was made payable by both Mr. Lay and his clients, first off. And that was because he filed a frivolous motion for default that had absolutely no basis in fact or in law. It led to a completely unnecessary hearing. And these are, by his own words, extremely poor people. They cannot afford to be paying sanction fees for his misconduct, for his inability to understand fundamental legal principles. So there's that. There's also the fact that he's talking about these health concerns that are immediate, that justified immediate action. But this class action case just languished for 2 years, and he never got past filing a complaint that could survive a motion to dismiss. It did no benefit to his clients for him to just struggle to file a complaint without calling someone a slumlord like he was repeatedly told to do. One of the cases I relied upon for disbarment is the Florida Bar v. Springer. It also involved a 6-count complaint. It also involved 28 rule violations versus 24 here. It involved a bar complaint that was filed in 2002 regarding conduct that was from 97 to 2000. But there was a pattern there, a lack of diligence, and then a dishonesty in trying to cover up the incompetence when clients were asking for status updates. And what this court said is the only appropriate sanction for this type of conduct is disbarment. For that reason, I asked for disbarment. I'll save the rest of my time for rebuttal.
Mr. Mason argues that Mr. Lee should be disbarred because his misconduct inflicted real injury on the very clients that he had set out to help. This argument is based in the Florida Standards for Imposing Lawyer Sanctions, the framework that Florida courts consult in calibrating attorney discipline. Standard 6.2 provides that disbarment is appropriate when a lawyer causes serious or potentially serious interference with a legal proceeding or knowingly violates a court order or rule with the intent to obtain a benefit for the lawyer or another, and causes serious or potentially serious injury to a party. During his argument, Mr. Mason pointed to the 2004 case of Florida Bar v. Springer as supporting disbarment in this instance. In that case, the Supreme Court of Florida disbarred an attorney following a 6-count complaint that charged 28 rule violations. The attorney had represented a client across a series of matters over several years, and in each, he failed to provide competent or diligent representation, and then misrepresented the status of the matters to conceal those failures. The court determined that disbarment was appropriate because the attorney's conduct reflected a pattern of neglect that caused serious injury to his clients, a failure to grasp the most fundamental legal procedures, and an intentional dishonesty that bore on his fitness to practice. Now, because the attorney in the Springer case had exhibited a similar pattern of misconduct, Mr. Mason argued that Mr. Lee's actions warranted the same result here.
May it please the court, Juan Arias on behalf of Mr. Lay. This case has always been about the degree of discipline to be imposed, even at the time of the final hearing. Mr. Lay appeared at that hearing. 10 rule violations were found, but he went to that hearing acknowledging, apologetic, and more importantly, was able for the first time to tell his story, because this court, this high court, probably is asking, what was he thinking in getting involved in these two litigations? Because that's exactly the first thing I asked when I got involved in this case. His personality traits are based on growing in a military family. He was a military brat, moving around. His father was absent in his military duties in the Air Force, enduring emotional and physical abuse by his mother, living in his home and family, leaving the home and family at a young age of 13, had devastating car accident that derailed his plan to be an athlete in Europe, rehabilitation and loss of reading skills as a result of that accident, circumstances of the murder of his girlfriend based on religion, the death of the mother of his young child, he's a father, and 2 heart attacks, all endured before he was 30. So the question that I've always had and that I posed to the court and I posed to this high court is, what do we do with individuals like Mr. Lay who come with a baggage that will reflect?
So I had a
his
similar
conduct?
question. I guess the flip side of that same question, though, is what is our obligation to protect the public? Why, if there's this continued pattern that's obviously negatively affecting the clients, should we take that into account more so than the impact to the public?
Justice Sasso, that's a great question because these two cases I was involved in were pro bono. On the second case dealing with Stony Brook, nobody wanted to touch that case. In fact, there's evidence and testimony from a community organizer who is the one that approached Mr. Lay because of the conditions of that location. So these were pro bono. Again, not excusing, but that is a fact in this case. So he jumped in, and his intent was to get the ball rolling, could get this case running, and then he could move out. He was not competent. The water was above his head. We know all of that. But he went in with a good heart. The attorneys or the opposing attorneys on both cases ran circles around him. And that did affect emotionally how he responded to this combination of his traits and what was happening, the frustration. Again,
Counsel,
not an excuse.
I'm sorry to cut you off.
Yes, Justice
Talk to me
Francis.
about why Springer is not applicable to this case.
Springer is not applicable because of several reasons, Justice Francis. And that has to do with the fact that that case is about, above all, dishonesty. And above all, can be distinguished because it also deals with lack of diligence and communication. In fact, in that case, to tell you how outrageous that case, the facts were, he falsified 24 certificates of title. I mean, this is massive misconduct of this man.
The bar's position is that that case is directly applicable because, apart from the numerosity of the complaints and the allegations against that particular person, we have a similar circumstance here, and the referee did specifically find, did she not, that he engaged in some level of dishonesty when he had a court reporter, intervene and ask questions to a represented person without opposing counsel there. He was also sanctioned, and his clients also were found also liable for the payment of those sanction orders. So why are those things not the same?
Well, they're not the same because the imperfect representation of Mr. Lay in that second case, the Stony Brook case, was a mixture of not only incompetence but overzealous effort to help these individuals because of their history and because of the history of the issues that have been already discussed before, the health, etc. He didn't have a selfish motive on those, unlike on this case where you have an attorney who is practicing on the private side and trying to make money out of these cases. That was not the case here. So he is the one, Mr. Lay is the one that disclosed that document. It was wrong, he took responsibility for that, and that is that. But the level of dishonesty on the Springer case and diligence is just another level. I think that the important part of this case today before this court is for the court to decide whether or not the standards apply to this case on the level of disbarment or on the level of suspension. And I would like to address the three standards because I know Justice Sasso had a question on it. And this is where we differ from the bar. We believe that this is a suspension case. Whether or not this is a 91-day suspension or 1 year or 2 years or 3 years, we believe that rehabilitation in this case is merited based on the background of this respondent, the type of cases he took, without the competence, but pro se, with a good heart. I think those things are very important. If you look at...
Counsel, if we were in a posture where we were considering your client's admission to the bar ab initio, like he had just taken the bar exam, and this was the record before us, do you think we should admit him to the bar where he's posting things like he's posting online, things I can't repeat on the record here? It would seem to me like he would have a very uphill climb. And so I guess, fine, I mean, let's say we were moved to suspend your client rather than disbar him. I can't imagine him being readmitted to the Florida bar with a record like this. Am I seeing that wrong? Is this someone who you think represents the kind of person you would want to represent your family in a dispute? Why should we admit him to the bar?
Just a Correal, it just happens that I do that kind of cases, and I appear before the board 3-4 times a month. Keeps me busy. And the beauty of the rules of the FBBE is that you get to show rehabilitation, because this court has plenty of case law that says people can change and can evolve and can learn and can contribute, because by making mistakes, you learn empathy towards others too. So I would gladly and proudly represent somebody that shows to me that he or she gets it, and that she has been rehabilitated.
Where's the evidence in the record that he gets it?
He testified, the remorse is there, and the court acknowledged that. He didn't go and fight all of these rule violations. He explained exactly the circumstances behind those cases. We did not go into that investigative hearing to just poke holes at everything. It just happened that count 2, which was mentioned by bar counsel, was flawed because it was so weakened. Yes.
Let me ask you.
Justice Decoded.
Yeah, as you know, I'm from Palm Beach County. I'm from West Palm. I'm familiar with Stony Brook. Stony Brook's been around. It's been a source of trouble. And, very poor people live there, are victimized by other people. And that development obviously needed someone to come in and do what your client did, help, offer their profession to help out. So I can understand that aspect, and obviously anyone would appreciate his effort to try to help out a very needy area. And I sat as a circuit judge in Palm Beach County for 13 years, and if I was to file a bar grievance for every lawyer who didn't follow my orders, I'd be testifying before the bar every day, because some lawyers just don't. But the question here, it seems to me, it's just, we're talking about the degree of the penalty that he's going to get here. And as Justice Sasso mentioned, we have, obviously we want to try and work with lawyers who kind of come off the rail and try to put them back on again so they can lead successful careers. But I mean, we also have to consider these clients who walk into his office and they see that license with our picture of our Supreme Court on it, and they have every reason to assume that we say this guy's okay. They have no way of knowing about backgrounds and things like that. I mean, we do have that obligation to the public and to everyone else also to make sure that the lawyer they're hiring is someone who's not going to behave like this. And he just had this inability to follow court orders for whatever reason. Why should this not, so we're talking about the degree of the penalty, why should he not be disbarred?
Justice LaVarga, there is evidence on the record that clients testify as to his professionalism in their case, and there is no evidence whatsoever that in the areas that he practices, which is family law and dependency, no issues. So these two particular litigations really rattled this individual, and I think that because of the nature of his personality, he just did not handle them properly. I want to address whether or not this is a disbarment of a suspension, and I'm going to address the 3 standards. The one on competence says that disbarment is recommended when the conduct demonstrates that the lawyer does not understand. We know that he's been practicing for many years in the particular areas that is qualified, and there are no issues. So suspension is appropriate when a lawyer engages in an area of practice in which the lawyer lacks competence and causes injury or potential injury. Then the second one, and I'm running out of time, so 7.1 requires intent to obtain a benefit, and the last one deals with whether or not he obtained a benefit, and that is abuse of the legal process. So the disbarment, that's not what we have here. None of those requirements under these 3 particular standards apply in this case. This is clearly a suspension case. These disbarment requirements require a little bit more. And we don't have the little bit more here because we don't have him trying to get any benefit. These were pro se cases, pro bono cases. In conclusion, the standards tell us that this court is to review and consider 4 questions. 1, duties violated. The lawyer's mental state I go back to his background. How does that background can help others in the future with a passion, with his big heart, because he has empathy, clearly. You can see it from all he endured in these cases where he felt that he was on the right. Incorrectly and perhaps incompetently. But you can't take that away. Where does that fit in these 4 questions? And then, of course, the actual injury caused by the lawyer and the existence of aggravating and mitigating. Then the comment tells us that you want to consider, and this is very important, the 3 objectives, which the referee clearly considered, 3 objectives of fairness to society to protect it, but not to deny the public the services of a qualified lawyer. The evidence is that outside these 2 cases where he was over his head, he is qualified, and we had testimony from clients. And there's no evidence that he has done any misconduct in family law or dependency. Then number 2, judgment must be...
Counsel, sorry to interrupt you. 10 seconds and then
Okay, yes, Justice. Then the last one is not to deny the public of the service, encourage reformation or rehabilitation. He has a lot to offer. He's come a long way. His background is just unique. This is a unique case. He may be an outlier, but it's a unique case. And I hope that this court recognizes that there is a lot of talent and passion and great service in the future, if given the opportunity.
Thank you very much.
Mr. Arias argues that Mr. Lee's conduct calls for a suspension rather than disbarment because he is capable of rehabilitation. In the 1983 case of Florida Bar v. Lord, the Supreme Court of Florida set out 3 objectives that govern attorney discipline. It must be fair to society by protecting the public from unethical conduct without denying the public the services of a qualified lawyer through unjustly harsh discipline. It must be fair to the lawyer by being sufficient to punish a breach of ethics while encouraging reformation and rehabilitation, and it must be severe enough to deter others who are tempted towards similar conduct. The commentary to Standard 1.1 of the Florida Standards for Imposing Lawyer Sanctions incorporates this guidance. In the same vein, the commentary to Standard 1.3 identifies the protection of the public as the primary purpose of lawyer discipline, the protection of the integrity of the legal system as the second purpose, and then lists the deterrence of further misconduct and the rehabilitation of the lawyer among its additional purposes. An attorney's rehabilitation also enters the analysis as a mitigating consideration, and Standard 3.3 lists so-called interim rehabilitation among the factors that may weigh in favor of a less severe sanction. Accordingly, Mr. Arias's argument was that the rehabilitative purpose of attorney sanctions would be best served by a suspension that permitted Mr. Lee to demonstrate his fitness and then return to practice, rather than the more severe sanction of disbarment that the Florida bar sought.
I've heard quite frequently that this is just an instance of 2 cases. This was an instance of 3 years of misconduct in his first 9 years as a lawyer. This can't be just separated out as, well, it was just 2 instances. Oh, he was overzealous because he had a lot of passion and empathy. This court addressed that very recently in the Florida Bar v. Schwartz and said overzealousness is not some personality trait that you get to use as a chit to cash in when you're facing discipline. He had a duty to be competent, to be professional. He didn't do that. He didn't attempt to do it in the class action litigation. Anything that he accomplished outside of the litigation had nothing to do with his behavior in court. I heard a distinction that, well, the Springer case is distinguishable because it involved dishonesty. Justice Francis pointed out that he did do dishonest conduct with regard to the taking of that deposition. I would invite this court to review Exhibit 94 of the bar's exhibits. It shows the text messages that went between Mr. Lay and the court reporter that showed he knew very well he could not meet with this witness, this represented party. And so he was sending her in there with a list of questions, with documents illegally obtained, and then I heard them say, well, he publicly filed it, he disclosed it, and so that took care of that. Well, he publicly filed them. And the disqualification order addressing that conduct says he did that with the intent to try and disqualify his opposing counsel.
The counsel on the other side sort of characterized this as there's the sort of macro protection of the public in terms of sort of general deterrence, but in terms of this particular lawyer, is disbarment more of a punishment, or do you believe that it's more prospective protection of the public if that were to be the outcome here?
I think it's necessary to protect the public.
From him or just from this sort of behavior in a sort of general deterrence kind of way?
To ensure his rehabilitation, certainly, because he didn't take any steps he needed to take to show rehabilitation in time of trial. For the public, because we shouldn't be facing in the future another instance where he undertakes representation, gets passionate and apathetic again, and then when things go sideways, suddenly he's just blowing up at people and using his childhood to say, well, I'm just a passionate person, that's how I was raised. You know, it needs to protect the court system because, for instance, these are just the court orders that address this misconduct. It'd be twice as big, but I printed it on both sides of the paper. It's a huge waste of court resources to deal with this type of misconduct. So, you know, for all those reasons, I would ask this court to disbar him. And I'm not saying permanent disbarment. I'm not saying he's beyond the pale and he can't come back and reapply for 5 years. Disbar him, he can apply again in 5 years and try to show that he's been rehabilitated. Thank you, Your Honor.
Thank you.
On March 13th, 2025, the Supreme Court of Florida issued its opinion, finding Mr. Lee guilty of all 24 rule violations charged in the bar's complaint and disbarring him from the practice of law in Florida. Mr. Lee petitioned the U.S. Supreme Court for review, but on October 6th, 2025, the court denied certiorari, declining to accept the case. Because Mr. Lee was not permanently disbarred, he will be eligible to apply for readmission after 5 years from the date of disbarment. This proceeding illustrates that attorney discipline is not principally about punishing a lawyer for past conduct, but about protecting the public from lawyers who cannot be relied upon to discharge their professional duties. Here, the bar sought disbarment as a measure to protect the public and the court system from a pattern of conduct that it believed lesser interventions would fail to correct, while Mr. Lee's counsel argued for a suspension that would punish the misconduct while preserving the possibility of a return to ethical practice. Both positions drew on the same governing principles, because the rules that structure attorney discipline consider both the protection of the public and the potential rehabilitation of the lawyer. The license to practice law carries the implicit assurance that the person holding it has been found fit to be trusted with another's interests, and the discipline system exists to make that assurance meaningful. When a lawyer's conduct calls their fitness to practice law into question, the decision between suspension and disbarment functions as a judgment about whether the attorney can be trusted to competently, honestly, and ethically serve and represent the public.